All right, what's up, everybody? We're back again. We're now on 15 USC 1692C, communication connection with debt collection. So this one right here is a very easy one, good one for should be very easy to understand. And there is some non-compliances here that you can, capitalize on, and we'll get to that towards the end when we get to being able to sue debt collectors. Okay. So let's start. 15 USC 1692C, communication with collection in connection with debt collection. A, communication with the consumer generally without the prior consent of the consumer given directly to the debt collector or the express permission of a court of competent jurisdiction. A debt collector may not communicate with a consumer in connection with collection of any debt. And then it goes down to list, whatever. But let's just go back to the top. Without the prior consent of the consumer given directly to the debt collector. All right. First of all, no consumer, no person is giving any consent to a debt collector for you to really contact. It's like we don't really want to talk to you, to be honest with you. So they already ain't got no permission from the consumer to communicate with a debt. And they sure ain't got no permission from a court, especially if they just had bought the debt from somebody, whatever. No court has issued them the permission to contact you. All right. So a debt collector may not communicate with their consumer in connection with the collection of any debt. And then now we're going to a list. At any unusual time or place known or which should be known to be inconvenient to the consumer. Okay. So unusual time, place, or place known or which should be known to be inconvenient. Okay. So when it said inconvenient to the consumer, you determines what's inconvenient. No one else could tell you what's inconvenient to you or not inconvenient. So if you contact it at any unusual time, what's the unusual time? Any time is unusual to me. So if you contact me at if you contact me at my house, a place, you send a mail to my address, that's an unusual place. I don't usually conduct business of debts or alleged debts at my house. My house is a place of resting and spending time with my family and stuff like that. So you are contacting me at an unusual place or a place that should be known or a place that's known to not contact me. Don't contact me at my house. You the one who could determine if something is inconvenient to you. Okay, unusual time. If you work for yourself, you're self-employed, whatever, anytime somebody contact you could be an unusual time. All right, anytime is unusual because you usually don't talk about debts, alleged debts, or whatever. Okay, so in the absence of knowledge of circumstances to the contrary, a debt collector shall assume. So assuming does not mean that it's fact. So they shall assume that the convenient time for communicating with a consumer is after 8 o'clock a.m. and before 9 p.m. local time at the consumer's location. So between 8 and 9 o'clock, they can assume that that is a convenient time to communicate with you. But they just assume. That's not a fact that the time between 8 a.m. and 9 p.m. is a good time to contact me, because in between those times, again, if I'm self-employed, if I do work for somebody, whatever, then those times are inconvenient for me. I don't want to talk about debt during those times or alleged debts, whatever. So here you could easily get a nice non-compliance violation out of this, because really anytime you contact me is inconvenient to me personally. So that's that right there. So that would be 15 USC 1692C. What is these parentheses? Brackets, whatever. So how you would write this would be 15 USC 1692C A1. So that would be like non-compliance for that. You contacted me at an unusual time. All right, so now let's go down to 2. if the debt collector knows the consumer is represented by an attorney with respect to such debt and has knowledge of or can readily assert such attorney's name and address unless the attorney fails to respond within a reasonable period of time to communicate with the debt collector, or unless the attorney consents to direct communication with the consumer. So basically what they're saying here, if you've been represented by an attorney, that's the person they should be speaking with, like the one before. So yeah, that's what that one is saying. This one is not really non-compliance here, because a lot of times you don't really have an attorney for this or whatnot, so kind of can just skip over that. But if you do have an attorney and and they go against that, then that's a non-compliance violation for you. Then we're going down to 3. Debt collector may not communicate with a consumer in connection with the collection of any debt at the consumer's place of employment if the debt collector knows or has reason to know that the consumer's employer prohibits the consumer from receiving such communication. So here, 3, this would be after you already let them know, or if they bought information from whoever they bought your information from, and it has your place of employment, then they shouldn't know or have a reason to know that your employer doesn't allow you to communicate about debts. And also, if you're self-employed, if you do get a call from them, let them know saying, hey, I'm not allowed to take phone calls from your company debt collection during my work hours. And then if they call again, then that's an easy, nice non-compliance violation right there, because your place of employment, you're not allowed to talk about such things. Okay. All right. So now going down, communication with third parties, except as provided in this section 1692B of this title without the prior consent. So no, you never gave no consent. Without the prior consent of the consumer given directly to the debt collector or the express permission of a court of competent jurisdiction, or as reasonably necessary to effectuate a post-judgment judicial remedy, a debt collector may not communicate in connection with the collection of any debt with any person other than the consumer, his attorney, a consumer reporting agency if otherwise permitted by law, the creditor, the attorney of the creditor, or the attorney of the debt collector. So I think it's this one. If not, it's another one I can kind of explain more about the consumer reporting agency. So here, a consumer report agency if otherwise permitted by law. Okay, so you do have the Fair Credit Reporting Act, which says, about the reporting of collection accounts or whatnot, but there's no law, I would say, that it is permitted per se, kind of. I don't know, I'm kind of confusing myself on that part, but a consumer report agency if otherwise permitted by the law. So it's not really a law permitting saying that the debt collectors are supposed to, they're allowed to report it and whatnot. Also, too, whenever you look at a debt collection reporting on your credit report, I always say that the terms are 1 month. You never set up 1 month terms with a debt collection agency ever anyway. So that's lying right there. But now let's go down to ceasing communication. So if a consumer notifies the debt collector in writing that the consumer refuses to pay a debt, or that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall not communicate further with the consumer with respect to such debt, except to advise the consumer that debt collection further are being terminated. So basically, they're saying, you set your cease communication. They're like, okay, well, we're done communicating with you. Just letting you know. Second, to notify the consumer that debt collector or creditor may invoke specified remedies which are ordinarily invoked by such debt collector or creditor. So they just let you know something that that they usually do. 3, where applicable, to notify the consumer that debt collector or creditor intends to invoke a specified remedy. If such notice from the consumer is made by mail, notification shall be completed upon receipt. So whenever they receive it, make sure you send it certified mail so you know the day they received it. And from that day, they shouldn't be communicating with you anymore, except for if it's 1, 2, 3 of these options. And what intends to invoke a specified remedy would mean, maybe that they plan to sue you, or whatever in that case. Consumer, same thing that was, well, this is actually added more onto from what it was in definitions. So for the purpose of this section, the term consumer includes the consumer's spouse, parent, if the consumer is a minor, guardian, executor, or administrator. So in this part here, the consumer is not only you, it's your spouse, parent, guardian, executor, or administrator. And what is just saying here, this is all just communication with the debt, directly with you, or um these other terms as a consumer. So here, like the non-compliance violation that you can have, is communicating with you at an unusual time or place that is inconvenient to you. If you're self-employed, or you can, have proof, tell them that your employer doesn't allow it, and they end up calling you again after you already told them that you're not allowed to speak with them, then that would be non-compliance. Communicating with you again after you told them that you wanted to cease communication and there's not one of these options, then that would be non-compliance violation of this subchapter here. So this is 15 USC 1692C, communication connection with debt collection. Hopefully I went over this kind of good. If you got any more input you'd like to go on, comment down below. But thank you for watching, and I'll see you in the next video.